So I press a button so that this is now being live streamed on YouTube. Today is July 14th of the year 2022. My name is Brad Gardner. I'm presiding judge over the first appearance hearing that's going to be held here today. So what I need everyone to understand is that we're not here to have a trial of your case or to take a plea in your case. We're here for me to tell you what you've been charged with or the charges that are pending against you, to set new court dates and to find out if you want to have a lawyer appointed. Those are the only three things that we're dealing with here today. During this and all other proceedings, you're going to have the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to testify on your own behalf or offer evidence in your own defense. And you have the right to have an attorney represent you. And if you cannot afford an attorney, one can be appointed to represent you. All of the bonds that are issued today are going to be by cash, commercial, or property. Cash bond, you can pay the entire amount of the bond in cash. That money will be returned to you by the sheriff's department once your case is resolved. You have the right to go through a bail's bondsman, and that's the commercial part, where you pay a fee to that bondsman for them to set your bond, or not set your bond, but pay your bond. And that amount is generally about 10 to 12% of the bond amount. Finally, you have a right to have a property bond. If you have property and the property has a value or net equity that is more than 3 times the bond amount, you can put that property up as collateral for the bond. Sheriff's Department will place a lien on that property, and when your case is resolved, they'll take the lien off. There are going to be, for certain people, there are going to be conditions placed on their bond to not go around a certain person or a certain place. And if you violate that condition of the bond, you will be charged with the felony of aggravated stalking. And that will result in your being placed in jail without bond until your trial is held. So it's very important to remember that. Lastly, everybody has the right to have a preliminary hearing. And the purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at that stage is very low. A judge only has to determine that the charge, as it moves forward, that there's a possibility that you committed the offense. Not that you did, but just a possibility. You also have the ability to waive your right to a preliminary hearing. If you're unsure about whether you want to waive your right to a preliminary hearing, you should speak to a lawyer first before making that determination. If you postpone, your preliminary hearing is going to be automatically waived, and you'll receive notice at the address that you give to the sheriff's department of your next court date. Lastly, could everyone please raise their right hand for me? Do you swear affirm that any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes. Yes, sir.
Okay, let's begin on the ladies' side.
Hi, good morning. Morning, Judge.
Good morning. Are you Miss Bentley?
Yes.
Miss Bentley, you've been charged with one count of a child abandonment. Bond is set by schedule, which means it's automatically set at $1,500. This is a misdemeanor offense, so your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That hearing will most likely be by Zoom. And as I said before, if you bond out, that hearing date is going to get waived and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry, man.
What was that, sir? I'm sorry.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes. Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, do you have any questions of me?
Yes. Well, I actually did not purposely miss my court date. I was actually attacked that night by my mother and okay. Well, yes, I had a change of address and the court date was sent to the wrong address. So I did not receive the hearing. I didn't know. I was unaware of it. And they did not send it to my correct address. So I did not know about it. So that was not purposefully.
Okay. So, ma'am, with this particular charge, are you the custodial parent of
Yes,
the child?
I am.
And is the alleged father, Mr. Is it Deaton?
Yes, Deton Johann Schroeder.
Yes.
Yes.
Okay. Well, so with this particular charge, if you're the custodial parent of the child, and if there is any evidence that you have taken custody of the child within a 30-day period, this charge should be dismissed. And my understanding was that for these hearings that there was an effort to make certain that there was personal service of all parties, so that there's not a situation where there's an allegation that a person didn't know that was going to be held.
Yes, and I'm sorry, he's refusing to give my daughter back to me. I'm sorry. Yeah, okay.
So what I would say to you, ma'am, was child born within a marriage or outside of a marriage?
Outside.
Was there any steps made to legitimate the child?
Yes.
So the father has been legitimated and named as father.
Yes. Now he has.
Okay.
Recently.
So you should speak to your lawyer about this, because from a standpoint of dealing with these allegations, if a parent is shown to have, for instance, taken the child for one day, child is at that person's home for one day, That's enough to satisfy the statute where the child is not being abandoned by the other parent. So you really, I would encourage you to speak to your lawyer and really
Yes.
take steps to protect yourself. Okay.
Yes, I have to, like, yeah.
Okay. All right, ma'am. You're free to go back.
Okay, thank you.
Miss Lawrence.
Good morning.
Good morning, Miss Lawrence, ma'am. You've been charged with one count of terrorist threats as a, let me see, as a misdemeanor, I believe. No, it's as a felony. Bond's going to be set at $5,000. You're charged with one count of disorderly conduct. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That most likely will be by Zoom. If you bond out, that date will get waived. Says here that you didn't fill out the form for court appointed counsel. Do you want me to determine whether you qualify for a lawyer?
Please.
Are you working, ma'am?
Right now, I'm not allowed to work because I'm currently, no.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes. So what happens to an officer who,
He's good, sir.
no,
I'm sorry. Hold on, ma'am. Come back. Ask your question.
what happens to officers who wrongfully arrest you and use excessive force?
You need to retain a civil attorney and go over the facts of your arrest with that civil attorney. And
What if you're
then,
homeless and you already told them that?
ma'am, you asked me how to go through the process. If the process doesn't change if you're homeless or if you have $1 million home.
Thank you.
Okay. You're free to go back, ma'am. Miss McCoy.
Good morning.
Good morning, Miss McCoy. You're charged with some possession of a controlled substance. Bond's going to be set at $3,000. You're also charged with possession of marijuana less than an ounce. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That's going to be most likely by Zoom. If you bond out, that date will get waived. Would you like for me to make a determination as to whether you qualify for the appointment of a lawyer?
Yes, sir.
So it looks here that you indicated that you're making $12,000 per month.
No, I meant 1,200. My bad. I put an extra zero.
Okay. All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I do. So my bond, I thought I had a different bond. They told me a different bond when I was in intake for the possession of marijuana.
So the possession of marijuana, it is set by schedule, which means it's automatically set at $1,500. The bond amounts that I tell people during this proceeding, the sheriff's department is required by law to add fees to that amount. And
Okay.
because I don't have that fee amount, I can only tell you the amount that I'm setting.
Okay.
And they'll get the amount that I set, and then they'll add the fees to that.
Could you repeat my bond again, please?
Yes. So it's $3,000 for the simple possession. And that's the peel.
Yeah.
It's $1,500 for possession of marijuana less than an ounce. But as I indicated earlier, that amount
Mhm.
will be higher because the sheriff's department is required by law to add a fee to that bond amount in both bond amounts.
If the pills is prescribed, that still doesn't matter, right?
Well, it does matter as it relates to whether you can be found guilty of this offense. But because I'm in a situation where I can't have a trial at this point, meaning I can't have both sides coming in and telling me what they believe took place. So I cannot make a determination about that right now. But if you have a prescription for that pill,
Yeah.
make sure you tell your lawyer that and you bring that, give that to your lawyer, and that charge will most likely get dismissed. Anything else, ma'am?
That's a felon, right?
It is a felony, yes, ma'am.
It's not no way I can like take classes first.
No, ma'am. Well, when I say I'm not the final judge that's going to make the determination as to what happens in your case. So first thing to do is speak to your lawyer about all the questions you're asking me, because your lawyer should be able to make those things happen.
Okay.
Okay?
Yes.
All right, ma'am. You're free to go back.
Thank you.
Miss Randall?
Yes.
Ma'am, you're charged with 1 count of criminal trespass. That's misdemeanor. Bond is going to be set at $3,000. You're charged with 1 count of battery. That's also a misdemeanor. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Theodore Brown. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That'll most likely be by Zoom. If you are bonded out, that charge will be or that hearing will get waived and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. You do qualify, ma'am. We're going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am. You're free to go back.
Thank you.
Ms. Strong? Ma'am, you're charged with battery. Bond's going to be set at $5,000. That's a misdemeanor offense. You're also charged with criminal trespass. Bond's going to be set at $3,000. There's going to be a stay away provision on your bond to stay away. I'm sorry, ma'am.
It's going to be a what again?
There's going to be a stay away provision on your bond to stay away from a Tawandria Josie. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That hearing will be by Zoom. That date will get waived upon your bonding out and you receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
May you repeat the bond? Okay, never mind.
Oh, it's $5,000 for the battery and $3,000 for the criminal trespass. Okay.
Yes.
All right, ma'am. You're free to go back. Miss Thomas. So can we bring Miss Thomas and Miss Honeycutt up?
Yes,
And
sir.
on the male side, can we bring Mr. Brimmer and Mr. Rhodes?
Up front. Over here, Mr. Bomber, side by side. Hands behind your back.
Okay, so I'm bringing the four of you up because you're all in the same boat. You're being designated as fugitives from justice, and what that simply means is that there's a warrant for your arrest out of a jurisdiction that is not within this state. Ms. Thomas, you are being alleged to be a fugitive from justice. There's a warrant for your arrest out of Flagstaff, Arizona. And it says it's a failure to appear for a drug violation. Miss Honeycutt, there's a warrant for your arrest out of South Carolina, and it says Morganton, South Carolina, that there is a probation violation for the charge of embezzlement. Mr. Brimmer, there's a warrant for your arrest, and it says it's out of Calhoun County, Alabama, in Anniston for violation of probation on a burglary charge. And for Mr. Rose, it says that there's a warrant for your arrest out of Calhoun County. Wait a minute. I'm sorry. Mr. Rose. Paperwork that I have attached to you, Ms. Rose, is for Mr. Bremer. So I'll come back to you, Mr. Rose.
All right.
But all four of you, you're in the position where the state of Georgia nor Clayton County has any interest in charges that you're being held on. We only through an interstate compact where another state says that they're gonna seek a person to be extradited, then Clayton County will do that. Hold the person for extradition. for all four of you, before I get into my spiel, I would encourage all four of you to hire a lawyer. If you do not have a lawyer hired already in the jurisdiction that's requesting for you to be brought back, because by doing that act, you may be able to short circuit this whole process, where the lawyer gets in contact with the prosecutor and the judge in your jurisdiction, and they may agree to have you released from Clayton County upon a promise to come back to court, and they'll set a new court date. And I've seen it happen within 2 or 3 days. I've seen it happen. So you should, no matter what I say, what goes on here, you definitely should consider hiring lawyers to represent your interests in those different states. Through this process, you have a right to challenge the warrant. And the basic issue that will be determined within 90 days is whether you are the person named in the warrant and whether the charges in the warrant actually exist. If those two conditions are met, the judge will sign off on the warrant. I can't tell you when that hearing will happen, but it will be sometime within the next 90 days. You also have the right to waive that hearing. If you believe you are the person named in warrant, if you believe that those charges are legitimate, then you can waive that hearing. And if you waive that hearing, the clock starts to tick today, and the requesting jurisdiction will have 30 days to come and pick you up. They can request an additional 30 days. If they do not come and pick you up within the requested time, you can be released out the front door, but the warrant doesn't go away. So it can be 5 minutes later that you're released and you run into another law enforcement officer. That officer runs your name and sees that there is a warrant valid for your arrest, and then the whole process starts over again. Am I being clear so far to
So
everyone?
you said they have 30 days to come and get us, correct?
From a statutory standpoint, they have 30 days, but they can request an additional 30 days.
Okay.
They may come in less time than that. I don't know, because I don't work for any of these people. But all I can do is tell you what the statute says. Does anyone have any questions so far?
Yes, sir. On mine, it's not Morganton, South Carolina. It's Morganton, North Carolina. And I'm Honeycutt's my last name.
Okay. Let me see. Okay. It's Morganton, North Carolina.
Yes, sir.
Okay. Okay. So I'm going to start with you, Ms. Thomas. Do you know whether you want to waive your right to a hearing or have a hearing?
What's the difference? What's the difference between that?
You said, what is the difference?
Yeah.
So if you say to me that you want to have a hearing, which is your absolute right to do, sometime between now and 90 days, there will be a hearing held. And at the end of that hearing, if the judge determines that you are Alyssa Marie Thomas and that these charges are valid. At the end of that hearing is when the 30-day to 60-day period begins to run. So if you believe you are the person named in the warrant, and if you believe the warrant is valid, by having a hearing, you're just adding the amount of time that you're going to sit here until you go to the next destination.
Okay, yeah, I'll waive it.
Okay. Miss Honeycutt,
Yes, sir.
do you know whether you want to waive the
Yes,
hearing?
I'll waive it.
Okay. So the deputies will give you the waiver paperwork, and once you sign that paperwork, they'll send it to me and I'll sign it, and the clock will begin running today. But as I said before, each of you should consider the benefit of having a lawyer in the other jurisdiction, so that you may even be able to walk out of Clayton County Jail with the court date in the future. Okay.
I have a question. How would you get in contact with a lawyer outside, like in Flagstaff? How would I get in contact with getting a lawyer in Flagstaff?
So it makes it more difficult, the fact that you're in custody, but you can attempt to call a lawyer or have family members attempt to call a lawyer, so that that lawyer then will start working on your behalf.
Do you think so? I was going through a separate case, and it said that my warrant was distributed in December, but I was out in Arizona in January through February, and they didn't tell me about any warrant that I had. And the judge that I went through, he told me I was good to come out here. So do you think the lawyer that I have for Maricopa County would be valid for Flagstaff?
It says like the warrant was issued on December 13th of 2021.
Yes, and I was out in Arizona in January of 2022, taking care of a separate case. And no judge mentioned any warrant that I had. They gave me the clear to come out here.
Well, I'll tell you, just from the basic experience of being a judge, law enforcement don't communicate with judges about stuff unless they're seeking a warrant for someone's arrest. So that judge may not have known.
Or do you think my lawyer that I previously had from my ongoing case would be able to help me with this one?
It's possible.
Because they're in different counties.
It's, the when I say it's possible, what I truly mean by that is I don't know that lawyer. I don't know that person. So I don't know if that person is on the ball or if that person is not on the ball. I don't know if that person was someone that, was in the know or not in the know.
Okay.
So, I mean, that's a question that basically has to get answered by the lawyer.
Okay.
Okay. Any other questions?
No.
Okay. All right. Well, once you sign those waivers, they'll send them to me, and you'll be free to go back. And the clock will start running today. Mr. Bremer, sir, do you know whether you want to waive the hearing or to have the hearing, or do you have any questions?
No, I have no question.
Okay. Do you know what you want to do?
Yeah, I've been through this before,
Okay.
and I've signed it.
Okay. So you're saying you're going to sign the waiver?
Yes,
And I would encourage you again, as I said to the ladies, get a lawyer. Make certain that everything is, if you can have this worked out. Because it says violation of probation. If you can have this worked out, where you can just leave the jail here
Yes.
and walk into court, that's always in your best interest.
yes, sir.
Mr. Rose,
Yes, sir.
do you know what you want to do, sir?
Yeah, I'm gonna wait. I'm gonna sign it.
Okay. Well, once you sign the waiver, you'll be free to go back, and the clock will begin to run today, and you also should seriously consider getting an attorney to represent your interests. All right, so once Mr. Rose and Mr. Bremer, once they sign their waivers, they'll be free to go back. And we can get started on the mail side.
Your Honor, before we begin, I do have your add-on, President, from yesterday, the Miles Davis
Okay,
and the Anthony Gates. That inmate was released yesterday.
yes, it apparently I was told, and I forgot, but that the wrong Mr. Gates was arrested.
Yes, Your Honor, he kept telling me that yesterday.
Yeah, and so they realized it, and so they were gonna arrest the right Mr. Gates. So with Mr. Miles, I don't have his warrant documents. I have a bond order.
We just sent it. Morel sent it to you.
Okay. Thank you, Ms. Jensen.
No problem.
Okay. So let's hold Mr. Miles until the end.
Yes, Your Honor. I'm gonna do.
So we should be beginning with Mr. Ba.
Yes, Your Honor. Sir.
Okay, Mr. Ba, give me 1 second. Mr. Ba, you've been charged with a number of driving related offenses. Speeding, bond is going to be set at $500. Defective equipment, so warrant number ending in 11. Bond is going to be set at $500. Violation of Georgia seatbelt law. Bond is going to be set at $500. Driving under influence of alcohol. Bond is going to be set at $5,000. Possession of marijuana less than an ounce, which is also a misdemeanor. Bond is going to be set at $1,500. Use or possession of drug-related objects. Bond is going to be set at $1,500. And distracted driving. Bond is going to be set at $500. Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That hearing will most likely be by Zoom. Would you like me to see if you qualify for the appointment of a lawyer?
Oh, I didn't hear what you said at first.
Okay, and I'll go back to it, but let me ask this question. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify, Mr. Ba. I'm going to appoint a lawyer to represent you. Now, you said you didn't hear what I said at first. Was that the charges or the bond amounts?
No, the bonds amount.
Okay. So there's $500 for the speeding, $500 for the defective equipment, about $500 for the violation of Georgia seatbelt law, $5,000 for the driving under the influence of alcohol, $1,500 for the possession of marijuana less than an ounce, $1,500 for use or possession of drug-related objects, and $500 for distracted driving.
But I was trying to get how much I gotta pay in total.
Okay, so it looks like the total is going to be $10,000 based upon what I've said, but the sheriff's department is required by law to add fees. So it's going to be a little bit more than $10,000, maybe $12,000.
I gotta pay that before I get out of here.
Yes, sir.
Okay, sir, no problem.
Okay. Any other questions, Ms. Ba?
No.
Okay, sir, you're free to go back. Mr. Calloway.
Hey, how you doing, Judge?
I'm doing well, Mr. Calloway. You're charged one count of cruelty to children in first degree. Bond is going to be set at $20,000. This is a felony offense. There's going to be a stay away provision on the bond to stay away from Alaya Calloway. Do you understand that, sir? Alaya Calloway. Okay. Your preliminary hearing date is going to be set for July 27th at 8:30 in the morning, courtroom 201. Most likely it'll be by Zoom. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. I was trying to see, wait, never mind. I understand. What's 10% of 20,000? If you don't mind asking.
2,000.
Okay, thank you so much.
You're welcome. All right, sir, you're free to go back. Mr. Duffy.
Yes, sir. Yes, sir, Judge.
Mr. Duffy, sir, you're charged with one count of simple battery. Bond is going to be set at $4,000. There's a stay away provision on this bond to stay away from a Virginia gauge. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You did not fill out the form. Do you plan on hiring your own lawyer?
We can.
Well, I said, do you plan on hiring your own lawyer?
No.
Would you like for me to determine whether you qualify for a lawyer?
Yes,
Are you currently working?
yes.
Approximately how much do you make per hour?
20, almost $22 an hour.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, no, sir.
Okay, you're free to go back, Mr. Duffy. Mr. Foster, are you Mr. Foster?
Yes, sir.
Sir, you've been charged with one count of criminal trespass. That's a misdemeanor. Bond is going to be set at $3,000. You've also been charged with one count of stalking, which is a misdemeanor. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sean Roberson. Do you understand that, sir?
Mhm.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No,
Okay, you're going to represent yourself, or you're going to hire your own lawyer?
I'll hire a lawyer.
Okay. Do you have any questions for me, sir?
No, sir.
All right, you're free to go back.
Thank you.
You're welcome. Mr. Hamilton. Mr. Hamilton, sir, you've been charged with one count of battery. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Francis Hamilton. Do you understand that, sir?
Yes, Your Honor.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You didn't fill out the form. Does that mean you intend on hiring your own lawyer?
No, Your Honor.
Would you like for me to make a determination as to whether you qualify for the appointment of a lawyer?
Yes, yes, Your Honor.
Are you currently working?
No, Your Honor.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, sir, you're free to go back, Mr. Hamilton. Mr. Harris.
Yes, sir.
Mr. Harris, sir, you're charged with one count of driving on a suspended license. Bond is going to be set at $1,500. One count of driving a vehicle with no tag light. Bond is going to be set at $500. One count of possession of firearm by a convicted felon. Bond is going to be set at $10,000. One count of theft or receiving stolen property. Bond is going to be set at $2,000. And one count of possession of firearm, a second count of possession of firearm by a convicted felon. Bond's going to be set at $10,000. Your preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Harris?
Yes, sir. I was booked in. I only had one count of convicted felon with a firearm.
So as of July 1st, the statute was changed that each weapon has a separate count. And so it appears that the allegation is that there were two weapons.
Okay, yeah.
So that's prior to the statute change, it will be one count. But legislature does what the legislature does. And so they made it each weapon becomes a separate count.
Okay.
Okay, sir, you're free to go back. Mr. Josie. Sir, you're charged with one count of battery. That's a misdemeanor offense. Bond is going to be set at $5,000. You're also charged with one count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a Taiwandria Josie. Do you understand that, sir?
Yes, Your Honor.
Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon the bonding out and you get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, Mr. Josie. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
All right, you're free to go back. Mr. Knox. Mr. Knox, sir, you're charged with one count of trafficking marijuana by Georgia's law. I cannot set a bond for this charge for anything more than 10 pounds. And in your case, there's an allegation of, I think, 26 or 29 pounds. So bond is going to be denied at this point, pursuant to Georgia statute 17-6-1. You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. You're going to have a bond hearing date set for July 29th at 8:30 in the morning. Do you want me to see if you qualify for the appointment of a lawyer?
Yes. Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, so the wait, what was the preliminary hearing and then the bond hearing? Like what's those two?
Okay, so the preliminary hearing date is a date where the prosecutor has to present evidence, and it's on a probable cause standard, which is basically 51%. So most likely the officer will bring in the person that arrested you to testify about the circumstances surrounding your arrest.
And then I will have a bond hearing on the 29th.
Yes, sir.
Okay.
A lot of times those hearings are combined, and so you could get a bond granted pursuant to your agreement to waive the preliminary hearing. And you should know, Mr. Knox, I mean, we get at least 5 or 6 of these cases a week of people coming from the West Coast. And a lot of times before you even got on the airplane, they know what's in the bag.
So I will get bond though, right? When I go to the bond hearing.
Most likely, yes.
Okay. All right.
Any other questions?
No, that's it.
Okay, sir, you're free to go back. Mr. Morgan. Mr. Morgan, sir, you're charged with one count of obstructing an officer. I have dismissed that count. And you're charged with one count of simple assault. I've dismissed that count also. So I've dismissed both the charges that are against you.
Thank you.
You're welcome. You're free to go back.
Thank you.
Mr. Robertson.
Yes, sir.
Mr. Robertson, sir, you charge one count of battery. I've set a bond at $2,000. Now place a stay away provision on the bond, stay away from a Trinity Smith. Do you understand that, sir?
Yes, sir.
I'm sorry, go ahead, sir.
Did she actually give you the particulars of the nature of why the plaintiff brought the charges?
No, all I have is what was put in the report, and it basically it alleges that you gave someone a massage that didn't ask for a massage.
Yes, sir. Shoulder massage.
And so without knowing more, I've set the bond at 2,000 because I cannot have sort of a trial of the case at this point. I may have, as I read it, I had some concerns about the allegation, but I would normally set a bond at $5,000 and for this charge. So I've set the bond at $2,000 and the stay away provision as it relates to Trinity Smith, so that you will have the opportunity to defend yourself as it relates to the allegations. Do you want me to appoint you a lawyer?
Yes, if you would, please.
Okay, I'm going to appoint a lawyer to represent you. Your next court date is scheduled for July 26th, but upon your bonding out, that date will get waived and you will receive a new court date in the mail. So I did, upon reading it, there were questions in my mind, but it's not something that I can make a decision about today.
I was saying that because I wanted to know whether I should waive the preliminary hearing, and if she sticks to the story that it was just in the clavicular area and nothing. Okay.
Well, I'll say this: once you bond out, your preliminary hearing is waived by operation of law, and I don't know if this case will get formally charged or not. I don't know. That's within the hands of the Solicitor General's office. But I would want to stay in a position where you're ready to respond to the allegations that have been levied against you. Okay?
Yes.
All right, sir. You're free to go back. Mr. Thomas. Mr. Thomas, sir, you've been charged with giving a false name, address, or date of birth. I've set the bond at $2,000 for that offense. The remaining offenses have been set by schedule, which means they're automatically set. So driving a vehicle without driving a vehicle while having a suspended license, bond is set at $1,500. Driving a vehicle with no insurance, bond is set at $1,000. Driving a vehicle while concealing the identification of the vehicle, bond is set at $500. Improper U-turn, bond is set at $500. And knowingly driving a vehicle with a suspended or canceled registration, bond is set at $500. Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, Mr. Thomas. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back. Mr. Williams.
Yes, sir.
Ms. Williams, sir, you're charged with 1 count of driving vehicle on the suspended driver's license. Bond's going to be set at $1,500. Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to determine whether you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own lawyer?
No, sir.
You're going to represent yourself?
Yes, sir.
Okay. Do you have any questions for me?
I have a quick downstairs. They told me my bond was $1,850 and somebody already paid it for me. So how does that work?
So again,
But it was through a Bill's Bonds company.
the sheriff's department is required to add fees.
Right.
So if I say the bond is $1,500, it's going to be more when the fees are added. I don't have access to that fee schedule, so I don't set the final bond. So whatever you've been told by the sheriff's department, that is the true and correct bond. All right, sir, you're free to go back. Mr. Miles.
Yes, sir.
Mr. Miles, you've been charged with 1 count of simple battery on a police officer. Bond is going to be set at $4,000, and 1 count of obstructing a police officer. Bond is going to be set at $2,000. Your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to make a determination as to whether you qualify for the appointment of a lawyer? Are you currently working?
Yes, sir. I work at Red Lobster.
About how much you make per hour?
13 hours.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes. I got a question because I ain't assault the police officer. I ain't put my hands on them. I got whiplash in my neck and I've been in a car accident. So I was just trying to tell them, let me sit down on my own. They were trying to shove me and push me in the car. They don't speak fast much. They just question. That's all, sir.
Okay. All right, sir, you're free to go back.
All right, thank you.
Your Honor, that was the last bill I have on the hillside.
I'm sorry.
Miles was the last meal that I had on the calendar, Your Honor.
Okay. All right. So it appears that we are done for today. I will see you all tomorrow.
Yes, Your Honor. See you in the morning.
Thank you for your assistance.